very fortunate to have Stuart Desky from Trisura to speak to us about the details. Stuart manages surety and warranty claims for Trisura, provides general legal counsel under the direction of the Senior Vice President of Surety. He has extensive experience managing surety, warranty, and other specialized insurance claims. Prior to joining Trisura in 2014, he was the Assistant Vice President Claims for a multinational insurance company where he had worked since 2002. He holds a bachelor's degree from McGill University and was called to the bar in Ontario in 2002 after receiving his law degree from Osgoode Hall, and I'm very pleased to have an expert. In my experience, people in the construction sector negate the importance of bonding and really understanding the bonding rules that are there now and the actual language of bonds, which are going to change. So I'm going to let the expert come up. Stuart's been very involved in preparing the new rules and drafting the new forms of bonds that are going to come as well. So Stuart.
Thank you, Ted, and good morning, everyone. I don't have any slides to put up, but I think that most of what I'm going to be speaking about today is pretty simple things to consider. The reason that bonds are so important in the new Act is that when the public policy sort of basis for why some of the changes to the Act have been made is, Minister Naqvi was really concerned about payments all the way down the line. You know, we haven't talked about prompt payment yet, that's coming, but that was a lot of the focus. And in order to sort of guarantee that prompt payment will work, the experience, especially the US experience, is that mandatory bonding on public projects is necessary. I don't know if many people know, but in the US that's existed for a long time. All the states and the federal government in the US all have statutes that require 100% bonds for all public projects. So the Surety Association of Canada was heavily involved in the consultation process of Reynolds and Vogel when they were doing this. And as many of you might know, Bruce Reynolds is actually one of the premier experts in surety law in Canada. And so when I say we, I'm going to talk about the Surety Association of Canada because I was one of the 3 people sort of on the subcommittee dealing with this issue for the last couple of years. And the Surety Association retained the Canadian Centre for Economic Analysis to research the economic benefits to the construction industry in the situation where mandatory bonding is required. And I can tell you that when the Surety Association retained CanCIA, we didn't know what their conclusion was going to be. It could have been, there's no advantage. We didn't know. But it didn't, in fact, they did conclude that there is significant advantage to the construction industry as a whole when mandatory bonding regimes are implemented. So as I mentioned, I was one of 3 people on a subcommittee that met with various ministries, met with Reynolds and Vogel, and which were really involved, not so much in the drafting of the bond sections, but more in terms of the bond forms themselves. So the new rules are such. All public projects, and public projects is defined in the Act, but just think taxpayer money. Anything where the owner is, or the construction is from taxpayer money. Any contract greater than $500,000 requires mandatory bonds, performance and payment with a minimum value of 50% of the original contract price. And these bond forms are on regulated bond forms, so they have to be the bond forms that the legislation sets out. As Ted mentioned, this is again going to come into force on July 1st, 2018, so anything that is considered under the new Act will require these mandatory bonds. So there are 4 new legislated bond forms. I've mentioned the performance and payment. There are also 2 other forms of bond. One I'm not going to talk about at all. It's a very, very specific situation. But one of them is also a holdback repayment bond. As Ted mentioned, holdback has to be paid mandatorily now. But now the Act actually allows holdback to be retained not in actual cash. It can be retained via a holdback repayment bond or as well as a letter of credit. So when an owner has a contractor, instead of taking that 10% off and holding it in their coffers, if the contractor provides the owner with a holdback repayment bond, the owner will be paying the entire amount of every invoice, and the security, the holdback that the owner is retaining is actually not cash, but actually that bond. But really what I'm going to focus on are the performance and payment bonds. And these have massively changed from what you've seen before. I don't know if people have looked at them yet. I mean, they only came out at the end of April. I can tell you that I've been working on drafting, and it wasn't really a negotiation with the ministry. We were giving our recommendations for how the bonds should look and how they should read. And luckily the ministry gave the Surety Association sort of the ability to sort of put its best foot forward and draft what we thought was something the industry could support. It went back and forth a little bit, and then just like everyone else, at the end of April, we found out what those bonds looked like. A key element here is the Act does not allow modifications to the bond forms. They have to be the way they are. The legislation does open a little window to allow increases in coverage. Basically, the sureties cannot, no owner or contractor or surety can draft a bond form that includes something that has less than what is in the bonds. But there is the opening that the owner can ask for something greater than. And I'll talk about that a little when we talk about things that are excluded in the new bond forms. One of the key things that bonds, previously performance bonds, the CCDC, which is most common, performance bond was 1 page and payment bonds were 2 pages. They are now 12 to 14 pages each. Now, it's a little bit, it sounds a lot, but a lot of this is because the legislation and the legislators wanted there to be a claims handling process that was legislated. And there was a talk about whether that's going to be in the legislation or in the bond forms themselves. And I think everyone agreed it made sense to be in the bond form. Why have a bond that people are going to make a claim on, and then you have to go to the Act or the regulations to figure out how to make that claim? So the bonds have now been drafted, and they read sort of chronologically. This is how you make a claim. This is the forms you use. This is, the Act is very strong in terms of forms. There's a lot of new forms. And so the bond themselves, part of those 14 pages, are the forms that you use, how you make a claim, the forms the surety has to respond to you with, and the forms that the surety has to give their position. So the claims handling procedure is set out. So a lot of people who may have, there's a lot of concern about bonds, and a lot of people have miseducation about how bonds are used because there was this unknowing of how the claims process worked. Now it's very, very clear. There are very clear guidelines as to what the surety has to do in the event of a claim, and there are now deadlines. So previously, sureties there was no deadlines in bonds. You made a claim on a bond, the surety is going to give you a position whenever it gives you a position. Now there are very strict deadlines. Number 1, for the surety to respond and acknowledge your claim, and number 2, for a formal position. And when I say strict, I mean very strict. The surety, depending on whether it's a performance or a payment bond, the surety has 3 or 4 business days to respond. And then in terms of giving a formal position on the bond, it's for performance bonds, it's 20 days after the claim was made. 20 days. For payment bond claims, it's 25 days or 10 days after the documents are received. So if a payment bond claimant provides all its documents to the surety with its notice of claim, the surety has to give a formal position in 10 business days, which is very aggressive. And if anyone's made claims on bonds before, I highly doubt that you've received a response in 10 days, unless it was maybe a flat-out denial. These are very aggressive. And I think a lot of people are sort of looking at the surety industry saying, you've now got a windfall. You've now got all this bonding that's required where people didn't have to buy bonds before. But I don't think the surety industry is looking at it that way. I mean, in Ontario, 90% of public projects were already bonded. You're really talking about MTO is really the big public owner that was not purchasing bonds. although I can tell you they were moving to bonding already. Surety Association had worked for the last 3 or 4 years with MTO to draft up their own bond forms, and they were about to implement that when this all came aboard. So, and one other thing just to mention in a general sense on the bond forms, as Natasha mentioned, the Vallard case, and a lot of owners who were buying bonds are concerned because they now have liability where they didn't have before. The timing of that decision was quite good for this process, because what the Ontario legislators did is they removed all the trustee language from the payment bond. I'm not going to get into the legalities of the third-party beneficiary rule and all that fun stuff, but suffice to say, the Vallard decision will have no relevance to public projects in Ontario, because the bonds have no trustee language. The right for a claimant to claim on a bond is in the statute. It's not based on other language. So that was timely. This is only for public projects. Private projects, there's been no change in terms of the bonding requirements. Private owners can purchase bonds or not purchase bonds. There's no regulated form. However, I think that private owners should really take a look at the new bond forms and consider what they usually use, which is most likely CCDC. There are a lot of advantages to every owner under these bond forms. It provides a lot of clarity. I'm not going to go through each of the bond forms. I gave a 4-hour presentation on what the bond forms contain a couple days ago. It's too long for this, but take a look at the bond forms. They're pretty simple to understand and read, and there's a lot of advantages there. And I think that a lot of private owners will start to move to use the same bond forms. CCDC, the committee was moving to revise the CCDC form of bonds. There was actually something drafted up that was ready to go, and once this process started with the new Ontario Construction Act, that's been put on hold, and CCDC is going back to the drawing board, and I think you're going to see new CCDC bond forms that look very similar to the Ontario bond forms, because it does provide a lot of clarity and a lot of guidance for what's included, what's not included. And what about subtrades? This requirement of bonds is just between owner and the prime contractor. It does not govern any requirement for bonding from let's just call it the general contractor down to its subtrades. However, one key item about the new bond forms is that the payment bond is a broad form bond. Previously, CCDC payment bond, one tier. So the general contractor, the payment bond covers all the people they have direct contracts with. If they're owed money, payment bond pays. Now, very similar to the federal form of bond, it covers the subtrades and the second tier subtrades. It's a limited coverage for the second tier subtrades, but there is still coverage. And I think that a lot of general contractors would probably want to make sure that they're covered off for that issue, because they don't have the same knowledge and understanding of whether or not subcontractors owe money down to their subs and suppliers. If they get a payment bond from their subcontractor, that will cover them for that issue, because there'll be now 2 bonds covering the same liability. But the case law and the practice has been that the first tier bond will always respond first. So I think that we've been telling our clients who are general contractors that they really should consider for their major subtrades getting bonds as well, because it covers them for those liabilities. I think that's it. I didn't want to go into all the different aspects of how the bonds changed. But if anyone has any specific questions about the bond forms or about bonding in general, please ask.